The defendant's argument about DNA and GSR evidence seems to be more of a chain of custody or foundation argument than the substantive argument about the reliability, no substance to her argument about the reliability of the evidence. The defendant's reply for the first time mentions the evidence being junk science, but she never presents any actual evidence or authority to establish the evidence was not reliable. Moreover, if there were questions as to its reliability, a competent and thorough cross examination could have revealed those issues for the jury to consider. Oh, wait, was her cross examination not competent, not thorough, Judge? Dare you say? Although the state chose not to call the person who actually collected the evidence Lachik, also spelled CIK here, the state satisfied the foundation requirements to admit the evidence through Detective Pillar, who, meaning they laid a foundation, who was present during the collection of the evidence. The reply also alleges hearsay statements from Lachik. Okay, I think they did an autocorrect, or not an autocorrect, they did a spell check, and then it came up obviously like with probably a red squiggly, and then they put add to dictionary, not noticing that the I and the C were inverted because it's consistently misspelled that way. Just for my fellow editors out there. The state satisfied the foundation requirements. Okay, the reply also alleges hearsay statements from Lachik were allowed into evidence, but does not state what those hearsay statements were. It is the court's recollection that no statements of Lachik were offered or admitted. They weren't, Judge. You're remembering correctly. What was she going to say? Ooh, that's some goopy blood I'm scooping up here. Finally, the court in no way precluded the defense from investigating this witness, as the defendant alleges. And in fact, the defendant could have subpoenaed and called this witness if she wanted to question this witness. Facts. The defendant fails to establish any due process violation which would warrant a new trial in this matter.